dignity should be maintained, and there is no violation on the part of police officer or any authority who is expecting the evidence. Yes, Your Lordship.
Urgency, after your colleague completes, you can answer then also. We will consider it.
No, it's fine, Your Lordship.
You may have time to think over it.
Yes, Your Lordship. So in shared single case, so there is the vague word that is not defined, and in the same, in my client's case is also dead. So, my contention is that there should be the definite definition of it, okay, and whether it is a procedural law or whether it is a definitional law, there should be the definite definition and should be the criteria on which the everyone is relying, and the procedural safeguards should be followed. Yes, Your Lordship. The Council seeks permission to carry forward with the submissions.
And one more question pertaining to issue number 1 itself.
Yes, Your Lordship.
Whether misuse of provision or misuse of authority by a agency would be a reason to
As it is mentioned in section 6 of this act itself, it is the nature of the matter. So if the person is resisting, so there should be the provisions that is mentioned in the section 4 that says that the central and the state has the power to make the rules for the furtherance, and they should be issued that in the Gazette. So in the Gazette, the rule number 11, it says that if the person is resisting or if it is necessary, so the police officer with the recommendation of the medical practitioner, here is the no link between the police officer and the accused person. The medical practitioner should be there who will take the evidences, not the police officer. But in case or in the good faith, if the police officer will take, so there he should be arrested according to the medical practitioner. And in my present case, there is no provisions like this. There is no judicial oversight. There is no medical provision. Nothing. The Council Commission to carry forward this issue. It is humbly submitting that the classification mandating non-consensual collection in cases involving women, children, and heinous offences is arbitrary in nature. Your Lordship, the Act mandates compulsory biological collection for the offences involving women, children, or offences punishable with 7 years or above. The classification is unconstitutional on very two grounds. That is, first, it fails the test of reasonable classification and imposes punitive consequences based on mere accusation. Secondly, it is arbitrary due to over-inclusiveness and under-inclusiveness. Your Lordship, Article 14 permits classification only on two grounds, which is laid in the state of West Bengal versus Anwar Ali Sarkar and repeated in the D.S. Nakara versus Union of India. That is, first, there should be intelligible differential. And second, the differential should have the rational nexus between the objective which is to be sought. Your Lordship, this is submitting that the object of Criminal Procedure Act 2022 is purely evidential in nature and facilitating the identification and the investigation.
So these are all policy matters. Vulnerabilities of a particular system would be taken into account by law methods. Why should we interfere with this?
The state should be
provision that is welfare of the society, not just the inclusive definition where everything can be included and the part or the excessive power can be held on the execution. There should be a definite definition of it. My contention
heinous offences, the offences which are against woman and child, requires a special approach, and that is what is being adopted.
Yes, Your Lordship.
We think we should not.
Article 15 provides for that.
Yes, Your Lordship.
When Article 15 provides for a special enactment as to women and children,
Yes, Your
I
Lordship.
believe that provision covered under Article 15. Then how you can say, how you can argue that that provision is foul because of in view of the special provision provided in Article 15.
So Your Lordship, I would counter this that firstly there are some cases which does not require investigation or per se they do not require evidentiary, but there are some cases which require, but just because that cases not fall under these categories which is formed by the act, those do not get the investigation necessity and do not comes under this. So there is non-consequential collection of the evidences. So my contention is that the law should be.
Can you illustrate a case wherein a question of collecting evidence doesn't arise?
Sorry, Your Lordship.
Can you illustrate an example where a question of collecting evidence doesn't arise? Just now you submitted that in some cases the question of collecting evidence doesn't arise. Therefore, I am asking you, can you illustrate any case?
So basically every case law, every facts are vary from one case to another case. So there may be the necessity of investigation and some cases may not be. This is up to the police officer and the investigation agency that can put their decisions over
So that
it.
is what the law is also saying. It is up to the investigating officer to decide. Let him decide.
They should decide, but with the procedural safeguards, not beaten up my client or without the due process of law. That's what is my main
So
contention.
your client was never beaten.
My client is beaten up. Yes, Your Lordship.
Is there any provision in CRPC which states that investigating officer need not commence investigation immediately or he need not investigate if he deems it fit so? Is there any provision in CRPC which states that investigating officer need not investigate the case?
So as far as I am concerned, there is no provision such that. Yes, Your Lordship. The Council's permission to carry forward with the submissions. Thank you, Your Lordship.
We feel you should sum it up. I think you have got only 1 minute time.
Yes, Your Lordship. Sir, Your Lordship, as I have mentioned earlier, that this is the over and under inclusive definition as it is stated in the state of Gujarat versus Mirzapur, Moti, Qureshi, Kasab Jama, that in this the Supreme Court held that the law becomes arbitrary if it is over inclusive and under inclusive. It covers more situation than necessary. It leaves out similar situation without proper reasoning. So, sir, this provision says the biological samples must be taken in all cases under certain categories of offences, but in reality, DNA or biological evidences may not be needed in every cases. And it is also under-inclusive, at the same time, there may be offences that outside of these lists where biological evidences is very crucial. But just because, since the law only focuses on the label of offences, those cases are excluded and the victims didn't get the justice. My main contention is that the law focuses on the gravity of accusation and the necessity of investigation, rather than instead of focusing on the whether biological evidence is actually necessary in the case or not, because of what the law wants to achieve, collect necessary evidences. And the law how actually operates automatically collection based on offense category. This is the violation of the Article 14 and the classification becomes arbitrary. Your Lordship, it is observed that the very provision of the Act is unconstitutional and violates the Article 14 on the very grounds that it has the vague definition. There is no procedural safeguard. There is the unguarded and canalized discretion over the part of executive, that is the police officer, and there is no rational nexus between the classification of the Act and the objective it is sorting. Thank you, Your Lordship. I would like to invite my counsel too for further submissions.
Please.
Kriti.
Counsel seeks permission to proceed with the arguments. Much obliged. Your Lordships, the second issue that I am addressing here is whether the act which is allowing for excessive whether the outsourcing of Abdul Fazil's biological samples to a private laboratory amounts to excessive delegation under the act and infringes his right to privacy guaranteed under Article 21. Your Lordships, this is excessive delegation of legislative power. It was supposed to be, the statute should have made it extremely clear how the data may be stored and by whom. However, they made rules that they allowed in Section 4. They said that the central or state government may make rules to notify how it may be done. And when these rules were made, it said that standard operating procedures made by the NCRB shall determine to whom and how it may be outsourced. This is not...
Counsel, according to what is being delegated?
Your Lordships, the excessive legislative power is being delegated by the legislature to the executive, which is NCRB, which is allowing for the NCRB to outsource the biological samples to the private
No,
company.
NCRB is not legislative.
Sorry, Your Lordship?
NCRB is not legislative.
No, it's not.
It is not.
Yes, it
So
is.
there is no delegation of legislative powers at all.
Your Lordship, there is a delegation of legislative powers because the Criminal Procedure Identification Act over here, it allows for the central and state government to make rules. Under those rules, they allowed for the NCRB to make standard operating procedures. Your Lordships, our contention over here is that these standard operating procedures are not mere technical matters. They are core policy choices, and this should have been made by the legislature instead of outsourcing it to NCRB. Your Lordships,
Counsel, all exigencies cannot be taken care in the principal enactment, isn't it? That
Yes,
is where
Your
the
Lordship.
rule-making power is given.
Yes, Your Lordship. The rule-making power was given. However, the rules which were made under that power, they allowed for the NCRB to make this. Your Lordships, in
So you have
Delhi,
objection for NCRB to do it. If it was something else, there was no objection for it.
Your
Is
Lord,
it what you are saying?
no, Your Lordships, what we are saying is that if the rules should have made clear, the rules should have mandated what the standard operating procedures was, because this is a function that should be performed by the legislature and not by any other agency. So it does not matter whether it was NCRB or any other agency. This was a function which should have been performed by the legislature itself. Your Lordships, in Re Delhi Laws Act 1951, Your Lordships may refer to the same in compendium at page number 9. It says that while ancillary or procedural matters may be delegated, core legislative policy functions cannot be delegated. Your Lordships, this includes the determining of legislative policy and laying down clear standards to guide executive discretion. Your Lordships, in the present case,
Counsel, this submission is running contrary to your contentions.
no, Your Lordships, it is not running contradictory because there was no clear standards for the executive to follow how it may be done. While the Act, of course, it did not give procedures for how the outsourcing may be done, whether or not it may be done, if it is to be done into what type of agency. It allowed NCRB to all of this without giving a procedure to how NCRB may. They did not even give a process for NCRB to make the standard operating procedures, in what manner they may make. Moreover, Your Lordships, the standard operating procedures are not publicly available information. this means that the person of ordinary intelligence does not know what is prohibited and what is not prohibited, which allows for them to step outside the bounds of law. Your
Counsel,
Lordship.
do you have any authority to substantiate that engaging a particular authority to do a particular act amounts to delegation of legislative power?
Your Lordships, as I cited in Re Delhi Laws Act 1951, and also there are a couple of other cases that we have mentioned in our memorial.
Which paragraph would you like us to read?
Your Lordships, paragraph 15 on page number 4 of our moot memorial.
Moot memorial, is it? Page number?
15. Sorry, paragraph 15, page number 4.
4. Please read, Counsel.
Yes, Your Lordships. It is respectfully submitted that the law on permissible legislative delegation is well settled. The Honorable Court held that with the Parliament may delegate ancillary or procedural functions, it cannot abdicate essential legislative functions. Essential legislative functions over here mean rule making, making the laws.
Your case is that NCRB has engaged another agency and has transferred data with them
Yes.
to allow the access of data. That is your case. Where is the question of legislative delegating the powers?
Your Lordship.
Excessive legislation or something?
Yes, Your Lordships, I understand. NCRB could only outsource this biological samples to the private company because the Act allowed for such. The Act allowed for the NCRB that by allowing NCRB to determine for themselves how and why it may be done, by allowing them to do the standard
NCRB
operating procedure.
giving the data or sharing the data with another agency may be excessive or delegated act by NCRB, but that doesn't mean that there is a delegation of legislative functions.
Your Lordships,
You
there
are submitting regarding delegative of legislative functions. Legislature has not delegated its functions. NCRB, which is required to store the data, it has outsourced it. So delegation is beyond what the legislature has prescribed. There is no provision for NCRB to delegate it. So delegation is by the NCRB, not by the legislative body.
Your Lordships, there are two ways about this. Firstly, NCRB has outsourced the biological samples to a private company. Yes, that is in excessive nature, because even if we try to read into the statute, into the vague statute, and still find some justification for the outsourcing, we are met with nothing but evidence to the contrary. As we can see in section, in section 4, clause subsection 3, it says that the state or union territories may notify an appropriate agency for which, and this is specific to state and UTs. It does not give for the central nodal agency. So firstly, the NCRB has violated whatever legislative scope they had, whatever statutory function they had, but also they could only do this because the vagueness in the statute which allows for the central state government to make rules. These rules were made, and in these rules it was given that the NCRB may make standard operating procedures for how the functions may be carried out of storage preservation. Therefore, it is both. It is excessive legislative delegation because the statute allowed for the NCRB to make rules for themselves. And then under these rules, NCRB gave the data samples to the private entity.
But Counsel, this is the question that we also asked your co-counsel. You are not challenging the virus of the rules. Why should we go into all these aspects when the virus of the rules is not challenged before us?
If your Lordships could please clarify the question.
I have seen the prior paragraph, Counsel.
Yes,
The
Your
virus
Lordships.
of the rules is never under challenge. Now, where is the question of the legislation being excessively delegated or not being considered?
Your Lordship, there is excessive delegation done by the legislature, and that is why the NCRB could outsource these functions further.
As per the issue number 2, if there are some safeguards, then it will be protected. That is what you want to submit. The act would be not ultra virus, the Article 21.
Your Lordships, the petitioners are not petitioning for the entire act to be declared as unconstitutional. There are certain specific provisions which are which are going against the constitutional safeguards, and petitioners are asking for only those either to be amended or to be declared unconstitutional.
Can we amend, counsel?
Your Lordships, the court cannot amend. However, the court can direct the legislature to pass the suitable amendment.
Can we direct it? Court can direct the legislature.
Yes, Your Lordship.
Do we have any authority or any article of the constitution which says so?
Your Lordship, the council is not
Court
aware
can
about the
direct
same.
legislative body to do certain things.
Your council, Your Lordship, there is a allowance for judicial review of the statutes passed by the Parliament, and therefore, under judicial scrutiny, if it is violating the Constitution, then the same can be directed to the
No,
legislature.
if it is violating, we'll strike down it. If question of issuing direction doesn't arise. Or else, can we put it in this fashion? Can we request the legislative body instead of giving direction?
Yes, Your Lordship.
So we'll
It will be
request
saved.
and we'll close the matter.
We
Your
ask the
Lordships,
legislative body to give some safeguards so that it will act, the provision itself will be safe,
Safe,
preserved,
please.
saved.
Your Lordships,
That's
if
what
suit-
your prayer is. If some safeguards are placed therein, it suffices your grievance.
Yes, Your Lordships, if proper safeguards which are adhering to due procedure established by law and which are allowing and are able to coexist with constitutional safeguards, then the petitioners shall be satisfied with this. And also, Your Lordship, you asked for the specific article. It is Article 13 of the Constitution of India.
What it says.
It allows for the judicial review of statutes passed by the Parliament.
Does it enable to give direction?
Your Lordship, the Council is not clear about this.
Then there is no point for us to entertain this petition, counsel.
Your Lordship, there is still a
You are
point.
requesting us to make some direction to the state, which we are afraid we don't want to do.
Your Lordships, in the broader interests of justice and safeguarding the Constitution, such a direction may be issued. Your Lordships, the second prong that we are on is that of the legality, proportionality, and necessity test laid down by K.S. Puttaswamy. The violation of privacy in the present case does not satisfy these. Firstly, legality. It says that there should be an existence of a statute under which any violation of privacy is run. Further, Anuradha Bhasin clarified that the mere existence of a statute is not enough. The statute must be such that it prescribes a fair, just, and reasonable procedure, which is absent in the present case. It does not give any procedure, let alone which is fair, just, and reasonable. Your Lordships, the
As
second...
far as the first test is concerned, we have got the enactment and the rules. That will take care of the first test in the Puttaswamy case.
Yes, Your Lordship.
That goes against you.
Yeah. Sorry, Your Lordship.
That goes against you.
Your Lordship, Council fails to understand how
Because
it
there
goes.
is an enactment and also the rules.
Your Lordship, Anuradha Bhasin versus Union of India clarified that the mere existence of a statute is not enough to satisfy the test of legality. The statute must be such that it prescribes a procedure that is fair, just, and reasonable. In the present case, it is not prescribing any procedure, let alone one which is fair, just, and reasonable.
What do
Your
you
Lordship.
mean by reasonableness, just, and fair? What do you mean by those concepts?
Your Lordships, firstly, fairness would mean that it is not arbitrary in nature and that it is allowing both parties in any case an equal, fair position, which is absent in this case because there is no procedure. It favors the prosecution's case because they are, under the scope of the act, they are allowed to collect measurements as they see fit. Secondly, fairness, it is unjust because it is going against the interest of justice in favor by going into the favor of the prosecution's case. And thirdly, it is not prescribing a reasonable procedure. There is no procedure to determine whether it is reasonable or unreasonable. Your Lordships, it fails the test of proportionality. There is,
What about the state's object, counsel?
Your Lordship, there is a legitimate,
state aim.
Your Lordships, we understand that there is a legitimate state aim, which is,
So the second test is passed.
yes, Your Lordship, for investigative purposes and keeping a secure database. However, Anuradha Bhasin versus Union of India also clarified that if there is a less intrusive measure which can be done to further the same state aim, then that must be taken. Over here, there is a specific branch, the data center and technical branch, of which major function is to major activities to build up, update, maintain a secure database on crimes, criminals, and property. In the existence and presence of a specified branch dedicated to this function. There was no need to outsource it to a private company. And therefore, it fails the test of proportionality and necessity. Your Lordships, this case bears a direct causal nexus. The facts of the case speak for themselves. The legislature passed an act which was vague. It allowed for the NCRB to outsource the biological samples to a private entity. There was a foreign cyber intrusion, and eventually leading to the violation of privacy of Abdul Fazil. If your Lordships are satisfied...
What is this proportionality test, Counsel?
Your Lordship,
In the background of the present fact.
Yes, Your Lordship, the proportionality test is that there should be a rational nexus between the legitimate state objective and the means taken to achieve them. In this case, the means taken to achieve the legitimate state aim was to outsource the data to a private company, which was not in proportion. When there was a specified branch which could have done this function themselves, the state could have done it themselves by the center. The act could have mandated the rules, could have mandated the procedures of how it is to be done, but both were not done. If your Lordships are satisfied with the
Counsel,
submissions-
handling of a data, can it be called as something that goes against the proportionality test?
Yes, Your Lordships. Your Lordship, Section 4 of the Criminal Procedure Identification Act gives that the NCRB shall, in interest of prevention, detection, investigation, prosecution, collect and record, store and preserve. Now, these were functions statutorily to be performed by the NCRB. There is no function, there's no mention of delegation. And therefore, when the proportionality, it is a statutory function, it's a statutory obligation, it cannot be delegated further. Your Lordship, Counsel seeks permission to proceed with the next submission.
One question, can you quote any provision under Indian Evidence Act or under the Information Technology Act to substantiate your arguments? Are you aware of that?
Your Lordship, if you could
To
please repeat.
substantiate your argument that storage and collection should not be delegated to a private agency.
Your Lordship, the
To
Counsel is not
substantiate
aware
your
of this
argument if there is
exercise.
any provision under the Indian Evidence Act or in the Information Technology Act.
Your Lordship, the Counsel pleads ignorance on this passage. Your Lordship, moving on to the third issue, it results in a violation of Article 20, Clause 3 of Abdul Fazil. It's submitted in three prongs. First, there's forced collection of biological sample constitutes testimonial compulsion. Your Lordships, in Nandini Satpathy versus P.L. Dani, it is given that any furnishing of evidence, any giving of information, if likely to have an incriminating impact on the case against the accused, falls under the ambit of being witness against oneself. In this case, the forceful collection of biological samples falls squarely within this meaning as given by Nandini Satpathy. Your Lordships, these provisions are vague of the Act and they allow for arbitrary collection of these biological samples. Your Lordships, unfortunately, it is inevitable that in such vague provisions, the prosecution will misuse the provisions to further their case by forcing the accused to compel evidence against himself. Your Lordships, the term measurements over here, it includes behavioral attributes. Now, behavioral attributes itself is an extremely vague term. It could even include, it would even authorize polygraph tests, narco-analysis tests to determine the behavior of the accused, whether or not he's telling the truth. However, these
Counsel, we have already taken a view that biological sampling would not come under the mischief of Article 20, subclause 3. Where is the question to revisit again?
Your Lordships, Article 20...
Counsel, you are aware of Selvi's case.
Yes, Your Lordship. Your Lordship, in this case, Selvi had explicitly outlawed the mandatory collection of narco-analysis, polygraph test, and brain mapping test. However, if we go according to the definition clause given in the measurements, it includes behavioral attributes. Now, behavioral attributes, if we just think logically by the meaning of the words, then it could also include these tests, but they have been expressly outlawed. Therefore, the provision authorizing compulsory collection without his consent violates his constitutional protection under Article 20, Clause 3. Your Lordship, biological samples subject to forensic analysis.
You refer to decision of Nandini Satpathy case.
Pardon?
You refer to decision of our Nandini Satpathy case.
Yes, Your Lordship.
Nandini Satpathy case states that third degree should not be used, which should replace the fish, and scientific evidence is permissible. Here, collection of buccal swab or body samples, these are the scientific methods of investigating the crime. So if you prevent the collection of these type of evidence, how can the state prove the offence itself?
Your Lordships, in the present case, his nail clippings were.
I'll add another thing.
Yes, Your Lordship.
You state that only biological collection of biological samples or behavioral attributes are violative. But our Act also provides for taking palm impressions, finger impressions, nail clippings. You are not offended by those collection of those samples.
Yes,
Then
Your
how do you
Lordship.
justify?
Your Lordships, the measurements clause, which is including all of this, the petitioners are not challenging every single term of this, fingerprints, palm impressions. Even the state of Bombay versus Kathikalu Okhad, it allowed for these. However, DNA samples are distinct from this, as they come into physical intrusion of the body. Moreover, Your Lordships, biological samples, when subjected to forensic analysis, generate incriminatory testimony, and they're not merely physical material evidence. Your Lordships,
Do you mean to say that accused should not cooperate with the investigation?
Your Lordships, the accused should cooperate with the investigation. In the present case, he had given his fingerprints, he had given his palm impressions. There were.
Nature of the offence is that he had committed a penetrative sexual assault
Yes,
against
Your
a
Lordship.
minor. Then collection of biological samples matters much.
Your Lordships, the function, as we can see in the moot prop, they were collected to establish a DNA link. Now, DNAs can also be extracted from hair follicles and nail clippings. Once these were extracted, there was no need for the police to further go and extract blood and buccal swabs. However, they did that.
What manner he has committed the offence, we cannot pursue the things, assume things. So, the collection of biological sample, even buccal swab, may be necessary.
Your Lordship, as we can see in the moot prop, para, Your Lordships, in para 5, the prosecution relied heavily on DNA analysis due to the lack of any other evidence. Now, DNA analysis, it can be extracted from less intrusive measures, that is nail clippings. It does not hurt the accused. However, blood samples and buccal swabs were therefore unnecessary to be taken in this case, when the DNA link and the DNA evidence could have been established only on the basis of hair follicles and nail clippings.
In another case, it may be relevant, most relevant evidence. If we hold that it violates Article 23, how can we make progress in the investigation in that other cases? In your case, you state that it may be not necessary because the hair follicles are there from where you can extract the DNA. But there may be some other cases seen more severe in nature where the DNA collected from blood or blood samples itself may be very relevant. How can we prevent one state has equal interest in crime being detected and punished?
Your Lordship,
Not only the rights of individual accused, even the victims has also right, in which society has more interest.
Your Lordship, the society does have more interest in broader justice and societal justice. However, the provisions, the petitioners are not alleging that in this present case, Your Lordships are satisfied. However, there can be more cases, as Your Lordships mentioned, in which blood samples may be required. However, the petitioners are only contending that there may be some procedural safeguards put in that are giving some scope of measurements, that are giving some scope of how and in what manner they be taken. In this case, they are absent, and therefore, the provisions authorizing such collection, the petitioner submit, should be declared as unconstitutional.
Had he cooperated, he would not have been subject to any force itself.
Your Lordships,
Because giving buccal swab or blood samples, they do not constitute or amount to giving incriminating evidence. Only the afford collection of evidence, which can be by linking to the facts in case, we can establish the relevancy. By giving, just like when you give finger impressions, it will not incriminate you. Similarly, collection of blood samples or buccal swabs will not incriminate you.
Your Lordships, the forensic analysis further of this would lead to incrimination. Your Lordship requests for 2 minutes more.
We will permit you.
Sorry?
We will permit you since you are swimming against the tide.
Your Lordships, further, from the reading of the facts of the case, we cannot infer that Abdul Fazil had not cooperated. We can see that he had given finger and palm impressions without any evidence, but only when he hesitated to provide biological samples and buckle and bloods and biological and buckle swabs. It is very natural to hesitate. Even when ordinary people go to get a blood test, we hesitate. Only because of his hesitation, he was subjected to physical violence. Your Lordships, if you're satisfied with our submissions, we seek permission to proceed with the prayer.
I can submit up, counsel. You're already running late.
Yes, Your Lordships. The petitioners respectfully request this court to adjudge and declare that the absence of a clear definition of measurements under Section 2, subsection D of the Criminal Procedure Identification Act 2022 enables the police to use excessive force on Abdul Fazil for extracting biological samples, thereby resulting in arbitrary enforcement, eventually leading to violation of Article 14 of the Constitution of Bharatiyana. Secondly, the outsourcing of Abdul Fazil's biological samples to a private laboratory without safeguards amounts to excessive delegation under the Act and infringes his right to privacy under Article 21. Thirdly, the provision authorizing compulsory collection of Abdul Fazil's biological samples without his consent violates the constitutional protection guaranteed under Article 20, Clause 3. Fourthly, the classification under the Act that mandates non-consensual collection in cases involving women, children, and heinous offences is unreasonable and it violates the guarantees of equality and non-discrimination under Article 14. And for this act of kindness, the petitioners, as are duty-bound, shall ever pay. Thank you, Your Lordships.
Is the voice modulation correct? Much obliged. The council seeks
For the
permission.
correctness, we cannot comment, but we can only say you are audible.
Much obliged, Your Lordship. The council seeks permission to address the bench collectively as Your Lordships. Much obliged. The council seeks permission to hand over the compendium to the Lordships. Much obliged.
There is no such regulation here.
The council, on the behalf of the respondents, will be the first speaker, who will be taking 20 minutes of the due time, followed by the second speaker, that is the co-counsel, that will be taking up 22 minutes of the due time. The first speaker will be dealing with the first and the third issues, followed by the second speaker, who will be dealing with the second and the fourth issues. With prior permission of the Lordships, the council would like to proceed to the arguments. Much obliged. Your Lordship, the first issue talks about whether the absence of a clear definition of measurements under Section 2B of the Criminal Procedure Identification Act 2022 enabled the police to use excessive force on Abdul Fazil for extracting biological samples, thereby resulting in arbitrary enforcement, eventually leading to the violation of Article 14 of the Constitution of Bharatiyana. Your Lordships, this issue will be dealt in a twofold manner. Firstly, by proving that the definition of biological samples mentioned under the measurements of Section 2 subclause B are not vague and unclear, but are specific and limiting. And secondly, that the force that has been used by the police in this particular case is not excessive, but it is reasonable in compliance to Section 53A of the CRPC, that is Section 52 of the BNSS. Your Lordship, moving forward with the first sub-issue.
Counsel, you are justifying force in this case.
Certainly, Your Lordship.
I must tell you that you are guilty of killing that person. We are using a very strong word against you. The state cannot do this, counsel.
Your Lordship, the state can actually use reasonable force in order to extract biological samples in certain cases, as it is also...
Have you read the death note, counsel?
Certainly, Your Lordship. Certainly, Your Lordship.
Please.
Your
We
Lordship,
can perceive the pain of the deceased.
certainly, Your Lordship. The death, so to answer your question, Your Lordship, the suicide that has taken place is not a result of the systematic problems herein, as stated by the counsels on behalf of the petitioners. The death has been alleged on the basis of the breach of his privacy and dignity, Your Lordships.
Who is responsible for that, counsel?
Your Lordship, in another situation, a state would be responsible, but herein, the second issue talks about delegation as such, leading to the breach of Article 21, that is right to privacy. Herein, the co-counsel will be dealing exclusively about the second issue. Henceforth, the contention of the state herein is that due to the delegation being rightful, the breach of privacy has not taken place, and hence it is not the liability of the state in this particular case, Your Lordship. May the counsel proceed to the arguments? Much obliged. Your Lordship, herein, the first sub-issue talks about whether the definition of biological samples is vague and unclear. Your Lordship, to resolve this issue altogether, the Rule 4 of the Criminal Procedure Identification Rules clearly states that for any involuntariness that is caused by the accused in extraction of biological samples, or so to say any evidence asked by the police can extract such samples by complying with the sections 53 and 53A of the CRPC, that is section 51 and 52 of the BNSS. Also, Your Lordships, it is further substantiated and provided under the section 2 subclause 2 of the Criminal Procedure Identification Act 2022, wherein it is clearly stated that any word or definition herein mentioned does not have a new meaning in itself, but it has the same meaning as provided to it under the IPC and the CRPC, that is the BNS and the BNSS. Your Lordships, as the Rule 4 automatically states that extraction must be done in compliance with section 53A. Your Lordships, section 51 of the BNS, that is section 53 of the CRPC, within there, Your Lordships, section 51 subclause 3A, that is the explanation of the word examination. It clearly states, and I quote, examination shall include the examination of blood, blood stains, semen, swabs in cases of sexual offences, sputum and sweat, hair samples, and fingernail clippings by the use of modern and scientific techniques including DNA profiling. Your Lordships, as it has clearly been mentioned in the Act itself that extraction has to be done in compliance with section 53A, and section 53A automatically gives what must be constituted as an examination, and hence these particular evidences so mentioned within the definition of examination must be considered to be biological samples in itself, creating a specific scope for the word biological samples here in Your Lordship within this particular Act.
When there is a particular section which specifies what biological samples may be, then why did you incorporate the same words in this Act, Criminal Protection and Identification of Prisoners Act? What was the necessary to duplicate it?
Certainly, Your Lordship. So, Your Lordship, to keep the definition concise in a manner, biological samples has been used as in order to represent these particular examinations that are biological samples, Your Lordships.
You not only say that biological samples can be collected, but you also refer to section 53 or 53A.
Certainly.
Why there was duplication? You could have just mentioned that just refer to section 53 or samples as stated in section 53.
Your Lordships, within the definition of measurements herein, it has been clearly mentioned that biological samples will be taken up. Now,
why that duplicacy?
certainly, Your Lordship, coming to that issue itself, it is to be interpreted in a reasonable manner, Your Lordship, that the intention and the objective of the legislature in this particular act was to concise the measurement, and the measurements that are provided within the definition and explanation of examination are construed to be biological samples, and herein to concise this particular definition, all these definitions that are biological samples in reality are constituted to be biological samples as in a singular meaning within the definition of measurements, Your Lordship.
Counsel, even behavioral attributes, you can't have it as vague and as open-ended as this.
Certainly, Your Lordship.
Anything that is vague is void.
Certainly, Your Lordship, to answer the question, behavioral attributes in this particular definition includes handwriting. Now, Your Lordships, handwriting...
It's an inclusive definition, Counsel. It's not an exhaustive definition.
Certainly, Your Lordship. To answer this question, Your Lordship, this question will be answered in the second sub-issue itself, Your Lordships. Your Lordships, moving on to your question itself. The definition of the principle of res judicata generis is to be understood in this particular fact, Your Lordship. The principle of res judicata generis clearly states of the same manner. Meaning here in Your Lordships that any word that is provided in a general term that is preceded by a specific term has to be incorporated and interpreted in respect to the specific term, Your Lordship.
So you want us to interpret, say, that includes must be read as to mean.
Could you repeat, Your Lordship?
Includes must be read down as to mean.
Your Lordship,
that is your submission.
Your Lordship, our submission is that whatever sample has been or evidence has been construed in this particular definition has to be construed in a specific manner and not in a vague manner. Also, Your Lordship, this is substantiated by the...
question of my brother is whether the definition of measurements is exhaustive or inclusive.
Your Lordships, it is an exhaustive definition in its entirety, Your Lordship. It is further substantiated in the case of Amar Chandra Chakravarti versus Collector of Excise Government of Tripura 1972, Your Lordships, wherein it was adjudged, and I quote, the principle of res judicata generis provides that when general words follow specific terms in a statute, the general words must be interpreted in the light of those specific terms, Your Lordship. In the present provision, Your Lordship, the term biological samples follows specific evidences such as footprints, palm prints, finger impressions, and iris and retina scans, Your Lordship. all of these forms of identification are derived to be of an external or semi-external nature, Your Lordship. It is to be construed that these particular evidences are not deeply invasive in nature, meaning that the definition of biological samples also must be read in a similar and limited manner. Thus, this interpretation removes concerns of vagueness and excessive scope, Your Lordship. This removes the question of scope of the particular definition. Moving on to the second question, Your Lordship, regarding the limits provided. It would be unreasonable.
Collection of samples, to what extent it may be? Can you draw 1 liter of blood from him?
Certainly, Your
Why
Lordship.
did not you provide any inputs there? With respect to specific biological sample, this should be the quantity.
Certainly. So to answer your question, Your Lordship, it would be unreasonable to expect from the side of state to provide a specific amount or quantity of samples to be collected in every single case, Your Lordship. It would be irrational because every case, Your Lordship, requires a different amount of quantity that is to be required, a different amount of sample that has to be extracted, and hence by creating a general and specific quantity for every single case in general would be irrational to this case, to this act as well, Your
Council,
Lordship.
understand what you did.
By this vague definition, you are giving unbridled power to the authorities to act according to their whims and fancies. They can extract anything, any quantity.
Certainly not, Your Lordship. Herein, as the definition of biological, would you complete your sentence, Your Lordship?
I have completed.
Okay. So, Your Lordship, to understand biological samples has been construed in a specific manner as to in compliance with section 53A, that is examination, Your Lordship. That is biological sample in itself. So, the police as well in this particular case, as the Lordships could refer to the third paragraph of the moot proposition on the second page, it is clearly and explicitly stated that the police collected whatever samples that could be useful. It is to be understood, Your Lordship, the police has collected whatever samples that could be useful under the boundaries prescribed under the explanation of the word examination, Your Lordships.
Council, there is no boundaries, that is the difficulty. It said photographs and you took the naked photographs of the person.
Certainly, Your
How
Lordship.
could you do that? That is where we are striking this down as being absolutely vague.
Your Lordship, to answer your question itself, coming to the point in the sixth paragraph as well, wherein the photographs were taken. Your Lordships, of naked photographs were asked from the accused, that is the then convict. He was convicted by the district court for aggravated penetrative sexual assault during that time while he was lodged in the Karnapura district jail. Therein, naked photographs were asked from the accused for a simple reason of identification, Your Lordship. It is to be understood, Your Lordship, that any mark or any injury mark that is present on the person's body may be hiding behind the clothes, Your Lordship, beneath the clothes. And it is to be understood, Your Lordship, that a person can easily change his appearance, he can alter
Well,
his
the
appearance.
walls could have been identified by you and could have been marked. Where was the question of taking naked photographs?
Your Lordship, naked photographs were taken in order to specify that this is the particular mark that is present on this particular part of the body, so that we have some form of evidence as well with us while identification is going on.
And what did you do with that evidence?
Your
Leak it
Lordship,
to somebody else.
Your Lordship, the delegation in this particular case that has done is rightful and that will be covered exclusively by the co-counsel. Herein, this particular act gave powers to the police for identification and investigation, Your Lordship. These photographs were simply taken to keep records of the evidences, Your Lordship, that are collected in the investigation and identification process. So to collect the records of the accused, that is the then convict in the case of aggravated penetrative sexual assault, these evidences were taken, Your Lordships.
But he was acquitted, Council.
Your Lordship, he was later acquitted by the High Court. But while he was lodged in the Karnapura Central Jail, he was a convict, as it has also been provided in the moot proposition. He's been convicted in the fifth paragraph, and the naked photographs that have been taken are mentioned in the sixth
Council,
paragraph.
understand, he was convicted and he went on an appeal and the appeal was heard, it was allowed and he was acquitted.
Your
You
Lordship,
can't call him a convict.
Your Lordship, but he was a then convict, and hence the police had to take identification of the person as he was a convict at that time for aggravated penetrative sexual assault adjudged by the district courts, Your Lordship. And hence the police has collected.
Do you collect measurements depending upon the judgment of the court or prior to it?
Your Lordships, we take for any evidence that is to be collected, it is collected before the conviction of the court. But Your Lordships, here in this act talks about two things. It talks about investigation and identification. So herein, while he was lodged in the Karnapura Central Jail, to identify the accused in the most efficient manner and in completeness, the police has taken naked photographs and has kept it safely, Your Lordship. Also, Your Lordship, it is to be understood that while naked photographs were being taken, he was present in front of a few wardens, Your Lordship, for the simple reason that he was a convict in a very heinous crime, Your Lordship. An aggravated penetrative sexual assault against a minor girl, Your Lordship. It is a very heinous crime. So in order to keep the
No, you
dignity
can't press
as well,
that, counsel. He has been acquitted.
Your
I do
Lordship,
not understand why you are pressing the very
Your
same
Lordship, but
thing.
he was convicted after this particular things had been done. Before these particular acquittal, he was still a convict in front of the law, Your Lordship. So hence, whatever has been done in the police authorities in this particular case has been done by keeping in view that the person was a convict at that time, at that point of time, Your Lordship. And hence, photographs
According to
have
your
been taken.
submissions, the definition of measurement is exhaustive. Then why did not you use the word means and use the word includes instead of it? In the definition which you can refer to,
Certainly,
measurement includes, that is the words which you have used.
certainly.
When you submit that it is an exhaustive, you could have used the word means instead of includes.
Certainly, Your Lordship. So, Your
Then-
Lordships, may you complete, have the Lordships completed the sentence? So, Your Lordships, to answer your question, herein the principle of ejus generis has been kept in mind by the state itself while drafting such laws, Your Lordship.
Counsel, if that principle was taken note of, you could have said that it means and includes. Why did you say it includes? You are making a different submission now before this court. You are now saying that it's an exhaustive definition, and you want to take umbrage under a interpretation of rules, these rules of interpretation of statutes. But your words refer something else.
Certainly
And
not.
your conduct says that you did something else.
Certainly not, Your Lordship. To answer your
Add
question,
to my brother's question,
certainly.
question of applying the principle of ejus generis doesn't arise in this case because even those are spelled out. Behavioral attribute includes signature, handwriting, and other examination. Where is the question of applying that principle?
Your Lordships, applying this particular ejus generis principle in this case is necessary for biological samples as well as interpretation of these particular evidences and samples that have been provided in the definition of measurements, Your Lordship.
Other
Here-
than biological samples mentioned in section 53, what else you would expect as a biological samples?
Your Lordship,
In section 53 you read now,
certainly.
as of CRPC, there are certain biological samples specified. Other than what else you want to expect? What do you expect
Your Lordships,
in this definition?
certainly, Your Lordships. So the principle of ejus generis herein is not in play for identifying what kind of samples that can be collected. It is for identifying, Your Lordships, in what quantity that they can be collected and in what way that they can be collected and in what way it has to be interpreted according to the law, Your Lordships. So when we're talking about it in the law,
So far as quantity are not at all specified, again question of applying the principles of ejus generis doesn't arise.
certainly, Your Lordship, as the council answered this question before as well, that it would be irrational from the state to it would be irrational to expect from the side of the state that we provide a specific scope and specific quantity of samples to be collected in every single case in general, Your Lordship. That would be an irrational act in itself because every case is kind of dynamic in itself and it has different facts, and hence the investigative authorities have been given the interpretation and the power of interpretation to take the samples in the manner that this case requires. And in this particular case, Your Lordship,
Can you illustrate a case wherein collection of sample to limited extent cannot be specified?
could you repeat, Your
Can
Lordship?
you illustrate a example or a situation wherein collection of samples could not be restricted to a particular quantity?
Your Lordship, so to say, whenever we're moving ahead in a court proceeding, Your Lordship, it is to be understood that one particular and once when a sample is taken, it cannot be deciphered that this particular quantity of sample is rightful, Your Lordships. Whenever we're moving forward in a case, it can be understood that on several different instances, the investigative authorities might need some different types of samples in different quantities, and hence the state has not provided any particular scope and limit on the quantity of the samples that have to be collected.
Can you illustrate it by an example?
Sir.
Have the state come across any situation or any case while legislating this act wherein it has come across that limited specifying limited quantity or particular quantity of sample is not safe? It is not wise to prescribe it.
Your Lordship, to answer your question, it is a very subjective question to answer, Your Lordship, for the reason being that
No, if you want to understand the provision more clearly, so that do you have any illustration to place before us to say that in this kind of situations, prescription of minimum sample would be not a wiser decision?
Your Lordships, to answer your question in a very concise manner,
You can reserve it after your co-counsel, you can answer that question. You can think over.
Certainly, Your Lordship, certainly. It is a humble honor.
You have got only 2 minutes time.
Certainly, Your Lordship. The Council seeks permission to proceed to the third issue.
Please.
Much obliged. Herein, Your Lordship, the third issue talks about whether the non-consensual collection of the biological samples of Abdul Fazil constituted to violation of constitutional protection as guaranteed under against self-incrimination under Article 20 subclause 3, Your Lordships. Your Lordships, it is to be understood that Article 20 subclause 3 in its bare reading protects any accused from being compelled to be a witness against himself. The ambit of this particular fundamental right, Your Lordships, only covers testimonial evidences into its ambit. In the case of State of Bombay versus Kathi Kalu Ogre 1961, Your Lordships, it was held by an 11-judge bench that biological and physical evidences fall out of the ambit of protection of Article 20 subclause 3, Your
Counsel, we
Lordships.
have come a long way from there.
Certainly.
We'll revisit that.
Certainly, Your Lordship. To answer your question in the further issue itself. Since then, Your Lordships, it is an accepted principle that only testimonial evidences fall under the ambit of Article 20 subclause 3, Your Lordships. The simple reasoning behind this being, Your Lordships, that testimonial evidences, which include oral and written statements, have a tendency to contain human error within them, Your Lordship. This also aligns with the right of the accused to remain silent in their court proceedings as well as extending to the court proceedings. Your Lordships, to answer the questions of the Lordships as well, it was further adjudged and the judgment of Kathi Kalu Ogre was further acknowledged in the case of Selvi versus State of Karnataka 2010, Your Lordships, that compulsion to provide fingerprints, blood samples, hair strands or DNA does not infringe upon the right against self-incrimination provided under Article 20 subclause 3, Your Lordships.
Counsel, what did you do? Paragraph number 3. Abdul Fazil suffered visible injuries such as bruises on his face, swelling under his eye and cut near his lips.
Certainly, Your
And you
Lordship.
are arguing on consent.
Certainly, Your Lordship. Your Lordships, herein it is to be understood that the Act as well as the Section 53A of the CRPC gives the police the power to use reasonable force in order to extract biological samples, Your Lordship. And herein the consent of the accused is not in question, Your Lordship. And especially if the petitioners are contending that the right of the accused has been violated, apologies, Your Lordship, that the right of the accused has been violated against self-incrimination under Article 20 subclause 3, they'll be held wrong merely on the fact, Your Lordship, that Article 20 subclause 3 only covers testimonial evidences and testimonies inside its protection, Your Lordship, and not physical
Counsel,
evidence.
what was the ground for acquittal?
Your Lordship,
Why was he acquitted?
the ground for acquittal, Your Lordship, that the prosecution failed to establish an unbroken chain of custody, Your Lordships.
Pardon?
And further, that the
Pardon?
that the
Accepted by you.
Certainly, Your Lordship, but herein it is to be understood, Your Lordships, when we are talking about testimonial evidences only cover into its ambit oral or written statements, Your Lordship. Article 20 subclause 3 only guarantees protection against testimonial evidences and not against physical or biological evidences.
In case of rape or penetrative sexual assault,
Certainly.
DNA samples of specimens will be highly incriminating. You can agree to that extent.
Your Lordship, not certain, because in the case of Selvi versus State of Karnataka 2010, it had been adjudged.
Positive testing of semen sample in the victim, is it not a evidence of commission of that offense?
Your Lordship, it is to be understood that firstly, whenever force is being used to extract DNA evidences,
I will come to that point.
certainly.
First, my question is whether testing positive test of the summons in a victim is a incriminating material or not. To be more clearly, does it prove the commission of offences, presence of semen?
Certainly, Your Lordship.
Certainly. Then if accused is made to give the semen sample, then it will directly incriminate him.
Certainly, Your Lordship.
Then
Your Lordship, to answer your question.
when he is not willing to give, and the fact which you want to collect from him is directly incriminating. That is what in Nandini Satpathy case has stated. If there is personal information given by him directly proving his guilt, it is confession. If there is any fact any fact which is
The
incriminates
council
him.
seeks extension of time, Your Lordship.
You can till answering my question you are permitted.
Yes, sir, Your Lordship.
If there is any other fact, any other material which directly incriminates him, then even that is prohibited under section article 20 clause 3. Here is a case wherein collection of semen directly incriminates him to the offense.
Your Lordship, to answer your question in a twofold or threefold manner, firstly, it is to be understood that even Nandini Satpathy and all the other judgments that have happened within the Supreme Court are talking about testimonial evidences and statements provided by the accused. Statements are different from an evidence, Your Lordship. Furnishing evidence is different from being compelled to be a witness against himself. Firstly, Your Lordships. Also, Your Lordships, in arguendo.
What is the difference between them? What is the difference between them?
Your Lordship, furnishing evidence basically means to provide any document or evidence, so to say, in this case. Testimonial evidences, on the other hand, talks about any statement, either oral or written, provided by the accused. And to, in arguendo, Your Lordship, to be explained to the judges, in this particular fact sheet, if in arguendo, today the court decides to provide the right of physical and biological samples under Article 20 subclause 3, from tomorrow onwards, Your Lordship, no accused will be giving out their biological samples by consent, Your Lordships. The entire criminal jurisprudence would come to a halt, Your Lordships, after then. Because then the state will not be able to aid any scientific investigations to any case, Your Lordships. And hence it will be very dangerous for the criminal justice system and the criminal jurisprudence of this country altogether, Your Lordships, if protection is provided to biological samples against self-incrimination under Article 20 subclause 3.
You have not still clarified what is the distinction between to be a witness and furnishing evidence.
Your Lordships, to be a witness basically means, within the definition of to be a witness, it has been covered that to be a witness, a person can only be a witness to himself by a testimonial evidence, Your Lordship. It was also provided within the case of Selvi versus State of Karnataka that if a person has to be termed to be a witness against himself, there has to be a personal revelation, there has to be a personal assertion, and a delving into the mental privacy of the accused, Your Lordships. Providing DNA evidence and providing biological samples is different from having a personal revelation, Your Lordship, and a personal assertion. And hence it has, there is a clear distinction between these two, Your Lordships. Furnishing evidence is separate and testimonial evidence is completely separate, Your Lordship.
Witness would be when during it will be during trial. Here is a case where you are collecting samples during investigation.
Certainly.
From that moment you are compelling him to be a witness.
So, Your Lordship, the Council would beg to differ on this particular point. Herein, within the definition of Article 20 subclause 3, it has been accepted that to be a witness against himself, there has to be some form of testimonial compulsion, and testimonial compulsion only limits itself to oral and written statements, Your Lordship. Furnishing evidence, so to say, is, for example, to provide fingerprints, etc. The Council seeks extension of time to answer the question.
You can,
Much obliged. So, Your Lordships, furnishing evidence simply talks about fingerprints or
no,
so.
you need to stop because this is the second warning that is given regarding the time.
So, may the Council answer the question? Much obliged, Your Lordship. Your Lordship, furnishing
No more further answering. It's done.
You have understood.
Certainly, Your
Now,
Lordship.
remember, if you can't convince a judge, then what needs to be done?
Certainly, Your Lordship. The Council concludes its arguments. It was a humble honor arguing before this bench, Your Lordship.
The Council would be addressing the second and the fourth issue in the present case. With the due permissions of your Lordships, the Council would like to proceed with the second issue. May I proceed, Your Lordship?
Please.
Obliged. Your Lordship, the second issue deals with whether the outsourcing of Abdul Fazil's biological samples to a private laboratory without safeguards amounts to excessive delegation under the Act and infringes his right to privacy guaranteed under Article 21. The Council would be dealing in the present issue under a twofold manner. Firstly, in proving that the delegation is neither excessive nor ultra-wise in nature, and that this delegation has further not led to the breach of privacy guaranteed under Article 21 of the Constitution. To proceed with the first limb of my argument, which is to prove that the delegation is neither excessive nor ultra-wise in nature, the principles of administrative law have to be taken into consideration. Now, Your Lordship, there are certain essentials for a delegation to be valid, which are that there should either be an express provision or a necessary implication. Further, that the primary authority retains control, and supervision, that the delegated function is administrative and ministerial in nature and not legislative, the delegate acts under prescribed guidelines and control mechanisms, and the ultimate responsibility remains with the state. I would request your lordships to refer to page 2 of the proposition, to page 3 of the proposition, wherein it has been mentioned in the last 2 lines of para 7 that where all the shared data is stored and access to this database was monitored and restricted to officials authorized by the government. And further, on the second page of the 7th paragraph, it mentions that Gene Secure was tasked with storing samples, operating service, and providing analytical assistance.
Counsel, before that, where is the source of authority to you to outsource such an sensitive data?
Certainly, Your Lordship. For this, there should either be an express authorization or a necessary implication. Now, on the grounds of necessary implication, the state would like to plead herein that there is a vast necessity of having a technical assistance through a laboratory which rather furnishes to be a sound system of handling such data. Now, to refer to this, we have attached in the compendium the data of crimes, flagged as the data of crimes, when we have mentioned how there is an increase and heightened number of crimes have actually led to such a vast record of crimes that now there is a need for this data to be preserved in a manner that technical assistance by Gene Secure was very essential to NCRB in the present case. Further, Your Lordships, it is also to contend that Gene Secure has no coercive, no adjudicatory or no discretionary powers in the present case. Everything is retained with the state and the NCRB itself. With the mere fact to substantiate this point, it has been mentioned in the moot proposition that the state has maintained an NDA with Gene Secure. Further, the NCRB has maintained
Counsel,
an
the
MOU.
question is, where is the source of authority for you to engage a private entity?
Certainly, Your Lordship, and that to answer is that...
Which provision?
Your Lordship, this is a necessary implication under the statute or the act per se, is because now there is
It is
a
an avoidable
necessity.
complication.
Certainly not, Your Lordship, because in the present case there is only a technical assistance that we are taking.
Can
and
you
that,
point out the provision which shows that there was necessity? That is what his question, my brother's question. Which
your-
is that provision which states that there was necessity?
Lordships, to prove the necessity is why we have attached the data of crimes showcasing that there actually is a very vast record of crimes per se, and that it has been increasing year to year. Now, in a population of crores, if the data is increasing even, let's say for like 7.2% in the present data of crimes, this is so huge in nature that technical assistance had to be encountered by Gene Secure in the present case, and that it has no discretionary powers per to say. So the question of legislative functions goes out of the ambit.
No, if you can't handle, don't collect it.
Your Lordships, but that is an inevitable thing because the NCRB's resolution showcases why NCRB was made in the first place to do this, and that retaining the primary authority, NCRB is furthering the provisions and aims of the Act, which is to preserve records and matters incidental thereto. Meaning that now since we are preserving data and storing data, we are also acknowledging and ensuring that this data is preserved on levels where we retain authority and ensure that the data is kept safely with the state.
Merely because on the quantity of data, you state that you have implied power or to delegate it.
Certainly not, Your Lordship. Rather, we are saying that this is a necessity of the hour, that we need to have servers which can store our data. And that we are still, the NCRB is a very competent authority and still retaining control of all of its data. And that only a necessity for storing samples per se has arisen.
This is what they have argued because it's completely arbitrary. You rely upon some data and according to your own conceptions, you cannot handle it and therefore you do such things.
Your Lordship,
You collect sensitive informations and thereafter prejudice the rights of the citizens.
certainly, Your Lordship, and for the arguments that the learned counsels of the petitioners have put forward, I would rather also like to point out that they have acknowledged the fact that the issue that they're trying to raise about the delegation is between the state and NCRB, and not the NCRB and the private laboratory, which is this Gene Secure in the present case. And that they have also...
So NCRB
contended-
should be absolved of the liability. That is your
Certainly,
submission.
certainly not,
Certainly.
Your Lordship. Certainly not, Your Lordship. Certainly not.
So what cost?
Your Lordship, to prove the same, it is
Now we
that-
want to hear on cost.
Certainly not, Your Lordship. We'd like to...
We have
bring
lost
into-
our citizen council.
Your Lordship, may the council keep the submission that it was proceeding with to prove that, certainly. So, Now, herein it has been mentioned that the state maintained an NDA and that this instrumented restricted any third-party involvement. This is the first step, and now since NCRB is under the direct control of Ministry of Home Affairs, further NCRB goes ahead and signs an MOU. Further, it also retains control. Now, the entire question of delegation comes herein for the learned lordships that you're asking about is the very basic fact that the outsourcing and the delegation per se is valid on the grounds that since we have not delegated any legislative function, since there is a necessary implication in the case, and since there is a control mechanism well apprehensive in the present case, through the facts itself, it has been established that delegation on these grounds is actually valid and that it fulfills the principles of administrative law that, that derives that such delegation can be held valid. Also for I would request you to refer the compendium where the case of the Gwalior Rayon silk manufacturing versus the Assistant Commissioner of Sales Tax has been attached. On page number 22, refers that the practice of empowering executive to make subordinate legislation within a prescribed sphere has evolved out of practical necessity and pragmatic needs of modern welfare state. Further, it also mentions that essential legislative function is the determination of legislative policy, proving the fact that legislative policy is enunciated with sufficient clearness, and that in the present case, without the sufficiency of legislative policy being delegated, that in the absence of such legislative functions, when there is a necessity and discretion that undoubtedly rests with the authority itself, then the determination of delegation is done by the authority necessary in the particular case, meaning thereby that the NCRB is a rule-making authority under the Act. And when the NCRB is performing its duties for such a long time, it understands the necessity in the most broadest manner and that it is competent to understand that necessity and that such delegation by NCRB should be held valid in the present case.
In the Act and the rules,
So,
even if the legislature makes a rules, it has to be placed before Parliament to pass it, or the legislative body.
certainly,
And,
certainly.
you state that NCRB is some authority is delegated to, and you make some provisions, and you are not having any responsibility. Even it is not to be passed through legislature or accountable to legislature. Is
Your
it not
Lordship-
arbitrary?
Your Lordship, actually, we are not shrugging off the
The
line.
right to privacy is a fundamental right.
Certainly, Your Lordship.
Whether you are permitted to share sensitive data to a private person, whether is it fair on the part of the government or a legislative body to enact a law without making proper without providing proper infrastructure to store or to save the data, that is sensitive data.
Certainly, Your Lordship. So I would like to answer the question of both Your Lordships. The first question is keeping ahead the record of any such law that has to be passed in front of the legislature. Now, the legislature has passed the Criminal Identification Procedure Act, and under which Section 4 has already made NCRB a rule-making authority, along with the rules passed by the central government. The rules of the present Act give NCRB this power to release any SOP on manner and measure in which it could have delegated. Now that has already been done, meaning thereby that this Act has actually gone ahead in the legislature and that the legislature has passed it. Further, to you Lordship, the question of privacy. First of all, the Council contends that the right to privacy is not absolute in nature and that to refer to that sub-issue under the second limb of my argument, it is to say that there are three tests that have been laid down in the case of Justice K.S. Puttaswamy versus the Union of India. Meaning thereby that, and I would like to quote, and also been referred in the compendium, so to say, is that access to an exploitation of individual personal data, whether by state or by non-state entities, must be governed by a legal regime, and that this legal regime has to satisfy a threefold test. Firstly, legality, which postulates the existence of a law. Secondly, need defined in terms of a legislative state aim. And thirdly, proportionality, which ensures a rational nexus between the object and means adopted. Now, for the first limb of the fold, which is legality postulating the existence of law. Now, since there is a law existing already, which encompasses NCRB the power to outsource, and that NCRB has outsourced in a manner which is very essential and necessary in the present case, this legality is fulfilled on the ground that since all the valid essentials of delegation have been kept on record.
Council, vagueness. Legality test will fail on the touchstone of vagueness.
Certainly not, Your Lordship. Since alongside proving that there was a necessity in the present case,
the Criminal Identification Procedure Act, which is satisfying the test of postulating the existence of law. Now, since this law is in existence and has been upheld at many occasions by the court itself, NCRB is a very competent authority under Section 4 of this law itself, and that legality has been prescribed in Section 4 of the measures of this Act itself, meaning thereby that legality has been fulfilled by the NCRB in the present case. For
Please
the-
submit on proportionality.
Certainly, Your Lordship. So, for the second limb of the argument, that is need, the council would not like to put more points in that because the petitioners themselves contend that there was rather a legislative aim and a need. So,
No, that
getting on to the
doesn't bind us. Their
proportionality.
contention doesn't bind us.
Certainly, certainly. So, since the respondents are responding to the contentions of the petitioners, it is just to say so. And thirdly, the proportionality, which ensures a rational nexus between the object and the means adopted to achieve them. Now, I would request you.
And on the facts, what did you do?
Sorry,
What are the collections that you did on facts?
collections.
Collections of samples,
Collect-
photographs, by
Certainly.
using force.
Certainly. Your Lordship, for reiterating the very fact that my learned co-counsel has already dealt with, is that, first of all, the force was to a rational nexus to the injury sustained. And secondly, that the collection was a very necessary process because the long title of the Act, which further proves what the aims and objectives of the Act are, is that this Act is to authorize for taking of measurements of convicts and other persons for the purposes of identification, investigation in criminal matters and to preserve records. Now, for identification, the taking of photographs was a very necessary thing that the state had to do. Further,
Why?
for the question
Why?
of proportion,
Why was it necessary?
because, Your Lordship, if there is a heinous crime in place, now this is how the state has to ensure that the conviction rates are rather brought into control, or rather there is no wrongful acquittal or conviction in
And
cases.
this is the way you are addressing the issue, by using force.
Your Lordship, for addressing this issue, it is only said that there is a
And
proportionality.
you leaked that data, isn't it?
Certainly not, Your Lordship. And
No, you
to-
said that NCRB had all the control over the data. So the leakage now cannot be attributed to the agency anymore, going by your submission. It has to be attributed to you.
Certainly, Your Lordship, and for that matter, I would request you to refer to page 3 of the proposition, wherein it
Now
said...
we'll go by your submission. You said that you have the control over the data.
Certainly, certainly, Your Lordship. But when we talk about the leak, Your Lordship, it is a foreign cyber intrusion attempt. Now, in a foreign cyber intrusion attempt, the state itself is a victim. Now, this is something that the state will deal with in the international forums per se, because this is something that has not happened because of the due diligence not taken by the authorities of the state, but this is something that has happened because of a foreign invasion. Absolutely unrelated to the fact that the state agencies or that the state was incompetent in handling the data, meaning thereby that we take full control
No,
of
it is
the...
your duty to ensure that the invasions will not leak such sensitive data.
Certainly, certainly, Your Lordship. So there are two things that the
See,
council
that is
like
where
to
the
put forward.
concern is. Now, first, the drawing of the samples, then not handling it properly, ensuring that it goes to the public domain, and then being circulated in the social media and other platforms.
Certainly, Your Lordship, but to reiterate the fact again, that since it is a foreign cyber intrusion attempt, it is not the due diligence not taken by the state per se. So it is something that the state is itself a victim to. And secondly, for the fact that the delegation is not being proper, the delegation rather is valid under those grounds which has been mentioned by the council. Now further, Your
You
Lordship...
don't plead victimhood being a state. Is it not unbecoming of a state to say, I'm a victim?
Certainly not, Your Lordship, but...
You are a mighty state council.
Certainly, certainly, Your Lordship, but the mood proposition is
And
absolutely...
you say that you will secure the rights of a citizen of your country.
Certainly, Your Lordship, because the mood proposition is absolutely silent on what happened after the foreign cyber intrusion happened. So, it is for a mere fact to understand that... It is for a mere fact to understand that something that the state will do or may not do is not something that can be assumed in the present case, and neither is the council authorized to state that before the courts because of the lack
No, the
of
fact
facts.
says that you did not do anything. That's the way it was. Did you make any order to take it down or did you take any steps? Absolutely nothing.
Certainly.
On the other hand, it was circulated in the public domain. That is what the facts state.
Certainly, Your Lordship, but the facts do not adequately mention the fact that the state did not go ahead and do anything at all. So it cannot be assumed that the state did not do anything at all. Similarly, in a manner that we are assuming that the state actually did not.
No action is inaction, isn't it?
Certainly not, Your Lordship. So because we have or have not taken an action is absolutely silent in the mood proposition, and it cannot be assumed. merely because of the lack of facts. And further, that there were enough safeguards by the state itself. So due diligence had been accompanied in the case. Further, if any foreign cyber intrusion attempt, then again, reiterating the fact this is something that we'll deal with in the international forums, because even we are a victim to it. Because this is something that has happened to our citizens, and we take full control of that, and we will be challenging that. But rather in the present issue, right now the contention is that this issue is pertaining to the breach of privacy in outsourcing per se, and that it is not extended to the fact of leak of breach of data. So this is something that we'll deal separately. So right now, if your
You
lordship...
can't escape the liability by stating this. It is who
Certainly,
you
certainly.
collected the sample, you who took the photographs and gave it to that agency.
Certainly, your lordship.
Despite
But-
arguing for 10 minutes, you have not convinced us from where do you derive the authority to delegate it. You just say that data. Whether the data would authorize you to impliedly delegate it,
Certainly not, your lordship, and that again to reiterate the fact...
delegation should be, implied delegation should be, it should appear from the words of statute itself or the rules, concerned rules.
Certainly, your
Can you
lordship.
point out any rules or section which impliedly authorize you to delegate the function of storing of data to any other agency?
Certainly, your lordship. So rules of the Criminal Identification Procedure Act give NCRB this authority to make the SOPs and the
Which is
measures.
that particular rule which necessary implies delegation.
Your lordship, necessary implication of the delegation is based on the necessity. The rule, rather, I would like to point out the rule. The rule 5, wherein it's the rule 5 and the rule 3, subclause 2, wherein the Bureau shall issue the standard operating procedures for taking the measurements, which may include certain things, and that further in rule 5, the record of measurements shall be stored and preserved in a secure and encrypted manner as specified in the SOP itself. So now NCRB becomes a rule-making authority under this, under the Act and the rules. Now NCRB has the power to make the rules under this Act and further to issue SOPs. So under the SOPs, the NCRB is deciding how and what data to be given and under what necessity could the data have been delegated. And the NCRB has performed its functions in the present case by doing and interpreting the rules in its manner which was suited to the NCRB.
Council, Section 8 of the Act, it is only the government which has got the power to make rules. NCRB has no power to make rules.
Certainly, your lordship.
Section 8 of the Act.
Certainly, your lordship. And under the provision of that, Section 8 has the Criminal Procedure Identification Rules of
Rules have
2022 been made.
That's it. NCRB has no rule-making power.
Your lordship, Section 4 rather of the NCRB gives it certain duties. And now the rule gives NCRB this authority of meeting out the SOPs. Now under the SOPs, NCRB has to decide what kind of data, where and to whom the data has to be given. So this is something that is
SOP
within the...
is for functioning of itself, not to delegate its functions.
Certainly, your lordship, but that is prohibited in a case where the legislative function is being given out. Rather in this case, it is only it is rather an administrative function which is, apologies, your lordship, which is being given out. So the state itself under Section 8 by making these rules have given NCRB an
You
authority.
can move to the fourth issue.
Certainly, your
We have
lordship.
understood.
Obliged, your lordship. So, your lordship, to conclude, this is that the NCRB's powers are neither excessive nor ultra-vires, and that there is perhaps no breach of privacy because the threefold test has been satisfied. Further, under issue 4, the question is whether the classification under the Act that mandates non-consensual collection in cases involving women, children and heinous offences is reasonable, or whether it violates the guarantees of equality and non-discrimination under Article 40. The Council would like to contend that on 3 grounds. Firstly, that the classification is reasonable. Secondly, that the non-consensual classification of bodily evidence is not arbitrary. And thirdly, that the 7-year threshold and the discretionary window are reasonable. Your lordships, in the first limb of my argument, to prove that the classification is rather reasonable, there are 2 tests of a reasonable classification that the state has to justify. Firstly, there should be intelligible differentia, and secondly, that there should be a rational nexus. Now, for intelligible differentia, lordship, it is a widely accepted division in criminal jurisprudence between common offences and serious or heinous offences. I would like to read out the proviso for your kind perusal. Your lordship, the proviso reads, provided that any person arrested for an offence committed under any law for the time being in force, except for an offence committed against a woman or a child, or for any offence punishable with imprisonment for a period not less than 7 years, may not be obliged to allow taking of his biological samples under the provision of this section. So the non-consensual collection is not so wide in its nature. Rather, the terms may not be obliged is leaving a discretionary window for crimes below this threshold to have or have not the consent along with the safeguard under section 5 of the
Council,
same
you
act.
enacted DPDP Act and you said that consent is mandatory. Now you are arguing that consent is not required. Your submissions are contrary to your own laws.
Certainly not, Your Lordship, because when we talk about the DPDP Act, rather, it relates to digital personal data, and that in the present case, the data that we are taking is for the examination and rather for the purposes of investigation. So,
Investigation was done. It is
Certainly-
thereafter that you take the photographs.
certainly no.
As your co-counsel said, he was already there in the custody. He was a convict according to him.
Certainly, Your Lordship, and rather to substantiate that point, the premise of consent is to give a person a choice. Now, the moment I start giving the accused a choice to choose whether he wants to give his biological data or not to give his biological data, we put the entire criminal system into a halt, and that it will be very difficult for the state rather to go beyond and
That's
function
all right.
according to
It is
the
his
act.
body, and he has got the right to keep every element of his body intact and onto himself.
Certainly, Your Lordship, but would that mean that we
That's
put
the autonomy that he enjoys, at least over his own body.
Certainly, Your Lordship, but would that mean the council
It
seeks
should
extension?
mean.
Would that mean that we put the entire victims at the stake of the fact that now the accused has a choice to choose? So the entire group of victims are now subjected to that policy, and now the cases which could bring the rightful conviction of an accused who is actually doing some heinous offense, which is why the state in present has made such acts. So we cannot put entire provision to a halt by mirroring this to one
As my
case.
brother judge was putting to the petitioner, Article 15 only protects special legislation in favor of women and children. How do you justify, even in case of heinous offences, the third one?
Certainly. So, Lordship, in the case of heinous offences, it is firstly, I would like to put on record the case of State of Gujarat versus Sri Ambika Mills, wherein the courts have recognized the degree of harms, wherein it is also stated that it is for the state to determine that what degree of harm can the state apprehend to make a reasonable classification. It is also put on record on the compendium. Further, the legislature is entitled to take into its consideration the societal impact and the evidentiary complexity of the cases. And that when we say of heinous offences, again, the premise of consent fails the entire criminal system why it was made in the first manner. Further, BNS and BNSS under criminal jurisprudence have accepted the 7-year threshold window, for example, in cases of bail, arrest or preliminary inquiry sections, that it has amounted the 7-year threshold as a very purposive window for identifying whether an offense can be heinous or cannot be heinous. So this is something that the criminal jurisprudence has been practicing for long years now, which is why the proviso holds to be a reasonable classification. As far as
Right.
rational nexus,
Time is up.
just the conclusive
No,
arguments.
No, we have run out.
Last question. Drawing a line at 7 years, is it not itself arbitrary?
Certainly not, Your Lordship, because the rational nexus then comes into role play because of a simple reason that the aim of this act was to identify and investigate. Now, since the investigation is so crucial in heinous crimes, this does not become arbitrary for a simple reason that the state is now purposing the entire legislation to the aim that it has provided in the act, and that this act holds true in its nature for purposing such aim, which is identification, which is why we contend that this classification is not unreasonable and that rather it is reasonable. If
What is the reason behind classifying the heinous as more than 7, not less than 7?
Your Lordships, actually, to refer to that, under section 5, we have not entirely missed out. So, in the proviso also, we write may not be obliged, firstly. And secondly, that section 5 of this act leaves a window that when the magistrate is satisfied that the purpose of any investigation, there has to be a proceeding or that expedient to direct any person to give his measurements. The magistrate can direct the person to give an evidence.
Why not offense under more than 5 also you have not included? You state that offense more than 7 years. For less than 7 years it's not obligatory. For more than 7 it's non-consent. Even if there is no consent they can collect. Why that arbitrary line? at 7 years.
Your Lordship, this is rather not an arbitrary line, but it is to be understood that there are some safeguards that are put under Section 5, that we are not entirely leaving out the offences below the 7-year criteria to their consent. That we are rather saying may not be obliged, and saying that if there is a need where they might be obliged, magistrate has the power to issue directions in cases where the necessary evidentiary complexity is so much so, and the state needs to go ahead. And again, to reiterate that there is a threshold window set by BNS and BNSS itself, that 7 years is rather a very reasonable classification of offences. So,
Yeah,
which is why,
understood. We can conclude.
certainly, Your Lordship, so to say that this classification is
Conclude on cost.
certainly, Your Lordship, that the classification is reasonable, that the discretionary window leaves that necessary evidence is not lost, and that thus it does not violate Article 14 of the Constitution of Bharatiyana. If Your Lordships may allow, the Council would like to proceed with the prayer. Obliged.
Being respondent, you have no prayer. Only prayer is to made by petitioners.
Certainly, but we would like to put on record certain things that we demand from you.
Whether respondent has we are entitled to make prayers.
Your Lordship, we just want to put forward our submissions in to ask what we
They have
can.
not come to the court. They have come to the court. Only prayer is made by them.
So, Your Lord, should I like submit my prayer in just 2 lines?
Very briefly.
Very briefly, Your Lordship. We therefore, in the lights of facts presented, issues raised, arguments advanced, and authorities cited, the Council, on behalf of the respondent, humbly prays before this Honourable Court to adjudge and declare that to dismiss the present writ petition being devoid of merit and uphold the constitutionality of the Criminal Procedure Identification Act, along with declaring the procedure adopted for collection of measurements by NCRB to Gene Secure as proportionate reasonable, to uphold that Article 20, Subclause 3 does not include the right against self-incrimination, and to declare that the classification under proviso of Section 3 of the impugned act aligns with the object, hence constitutional, and or pass any other writ, order, directions or relief that it may deem fit in the interest of justice, equity, fairness and good conscience. For this act of kindness of your Lordship, the respondents shall duty bound forever pray. Thank you. It was an honor arguing before this honorable bench. Obliged.
Do you have a reply? You have no replies, no?
Time is up.
Generally, as a sitting in open court, you will ask the other side, do you have any reply? No, it is difficult time for us to judge. We can conclude. You have reply, you can.
Please, please. Very briefly, madam.
Yes, Your Lordship. As my learned counsel has mentioned that there is the procedural safeguards under the section 53A, but in my current case, there is the absence of medical practitioner. As the law itself says that on the a practitioner can collect the evidences, but here there is no medical practitioner, and if there is a good faith, the person is collecting it, there should be the request at which the person, there should be a request of the medical practitioner, then the person can only collect the evidences. But
See,
here,
that provision, this act all deals with the investigation, collection of evidence. They have
Yes.
to be read in harmoniously.
yes, Your
You
Lordship.
have to, all those acts or provisions apply simultaneously. There is no
Yes, Your Lordship.
conflict between them. So, necessary guidance is to be obtained from CRPC itself.
Yes, Your Lordship. So, Your Lordship, so
You cannot
basically,
say that it is an unguided one. Necessary guidance is provided from CRPC itself. Even as he pointed out, Act says that whenever there is any lackness in this Act, you can refer to the CRPC and IPC for definition purposes. And even CRPC applies it. And this Act is in aid of CRPC.
yes, Your Lordship. So, in my current case, the accused is resisting for giving the evidences. That's why it is applying. And my learned counsel has not defined that how exactly there is a procedural safeguards, because there is not a medical practitioner, and as well as there is not the issuance or the prior permission from the magistrate as well. As they have mentioned about the necessity of DNA extraction, but I would like to just clarify that there is already the alternatives available. The accused can identify the culprits, as there also that the DNA can also be collected from the footprints. The DNA can also be collected from the hair follicles and the blood samples. So why there is only the sole cases based on the DNA extraction? And as they have mentioned about the S. judem generis, Even if this applies, this is not applied to the definition of the photographs in biological samples, like what extent they can be extracted. As well as your lordship, the petitioners are not asking for a blanket ban on the compulsory collection of the blood, other biological samples. It is only going to hold criminal jurisprudence. As my learned friend said, the petitioner are only questioning the specific provision of CPIA 2022, which if safeguards are put in the place to satisfy coexistence with the constitutional provisions. They have mentioned about the non-disclosure agreement and the MOU. But the NDA and the MOU are not technological safeguards to secure the database. They are only administrative assurance. Providing analytical assistance was not the task one. There was only the task of storing sample, operating the servers. No legislative scrutiny on the SOPs, which SRB NCRB makes. Therefore, excessive delegation is there. It was not an
Madam,
attempt. It
conclude,
is
please.
intentionally
Time is up.
intrusion.
Time
Last question.
Yes, Your Lordship.
Since the victim has died already, the present petition is more
So,
academic.
Your Lordship, it is not audible.
Since the victim has died,
Yes,
the
Your
present
Lordship.
petition is more academic in nature.
So, Your Lordship, can you please
During
clarify?
his lifetime, the victim did not exercise any of the rights available to him. Now his father is challenging the act.
Yes, Your Lordship.
Is it not merely raising only academic questions, the present petition? Permitted. Can use the mic.
Your Lordships, in the present case, it is more of an academic discussion. In Annexure 1 of the suicide note, in the given mode proposition, Abdul Fazil says, I beg of you, whoever reads this, not to let anyone else face what I had to face. My life is over. At least save others. This is the purpose of the current writ petition, so that no one else ever has to face what Abdul Fazil had to face.
Thank you.
Thank you, Your Lordship.
No, we'll conclude it. There is, on which point you want to reply? That is the question. You already answered. No, first they made their submissions, then you have replied. To reply, there will be no counter reply. Further, there is no issue left which requires.
No, they are not keen on striking down the provisions, so you need not be apprehensive.
Yes. Will you?
Your Lordships, firstly answering the question of my learned counsels on behalf of the petitioners, this act actually includes medical practitioners within its rule as well under the Rule 2 subclause B of the authorized users, Your Lordship. In addition to that, Your Lordship, specific guidelines have been provided under the rules as well regarding manner and method of collection. That is provided under the Rule 3 of this particular Criminal Identification Procedure Act rules, Your Lordship, 2022, wherein Rule 3 already talks about the manner and method in which collections of measurements have to be taken. Hence, there is no arbitrariness from the side of the respondents. The police is simply abiding by the rules and the interpretation of the statute that it has been granted power under. In addition to this, Your Lordship, necessary guidelines are also provided with under CRPC, as the rightful judges just stated, as well as under Section 53A of the CRPC. In furtherance to this, Your Lordship, the petitioners within their oral rounds as well as in their rebuttals have themselves agreed that their client was actually resisting in providing their biological samples, and hence the police has used force in order to extract such biological samples within the Rule 4 of the Act as well as the under compliance with Section 53A of the CRPC. In furtherance, Your Lordship, the requirement of samples, as has been stated by the learned counsels on behalf of the petitioners, the requirement of samples differ from case to case, Your Lordships. For example, in this particular case, whenever we are discussing a case over rape and sexual offences and gang rape, any whatsoever grave and heinous offence against a woman, we have to understand that in such cases, semen and FSL samples are required and they are considered as of utmost importance, as well as blood, semen and FSL samples. These particular evidences are collected on a necessity basis from case to case, Your Lordships, and hence it is not possible for the state and it is irrational to expect from the state to provide a specific sample, scope and limit over the collection of biological evidences, or so to say any evidence in this particular case, Your Lordship. Further, Your Lordships, we have not talked anything about SIM cards as stated by the petitioners within the rebuttals, Your Lordship. We have not talked anything about SIM cards, so to say. And in addition to this, Your Lordships, when we're talking about safeguards, that there are lack of safeguards provided under this act, Your Lordships, it is to be understood that the safeguards were already taken by the authorities within the moot proposition itself under paragraph 7 and 8, Your Lordships, wherein firstly, the NCRB has signed a memorandum of association, memorandum of understanding. Secondly, the state has signed an NDA, a non-disclosure agreement with Gene Secure Private Limited, binding the information between the two parties, which is a good enough safeguard to be considered even in this case. And in addition to this, Your Lordship, the operating servers was simply kept for the use of government officials and nobody else, Your Lordships, meaning that the information could not have been used by anyone else other than the government officials. That is the authorized user in this particular act, Your Lordship. And hence, particular and proper safeguards have been taken by the state in this particular fact sheet and in this act, Your Lordship. Hence, the state is not liable for the breach of privacy in this particular case, Your Lordships. And in addition to this, Your Lordship,
Council, one question. The state is permitted to delegate sovereign powers because law and order is invariably a sovereign power. And such being the case, whether state is permitted to delegate power to the private agency or authority to store private data or sensitive data of citizens.
Share the data.
so Your Lordships, to answer that question, my co-counsel
It
has
is
already...
permissible under the constitution to delegate sovereign powers to some private agency is the question.
Your Lordships, within this
Because
particular...
NCRB, without any power or authority, that entered into a MOU with private agency and they shared the data for saving or storage. When such being the case, the primary question is whether state is permitted to delegate to do sovereign act to a private agency is the question.
Your Lordship, to answer that question, it is first of all stated herein that there is no delegation of essential legislative function in the present case, and that sovereign powers have not been delegated to Gene Secure in the present case. And since there is an absence of sovereign or legislative powers being delegated to Gene Secure, the entire question of whether it could have been invalid on that ground does not sustain, first of all. Secondly, it definitely is a case under administrative law that essential legislative functions cannot be delegated, and that NCRB has certainly abided to that sincerely for a mere reason that only storing of samples had been delegated, which is not an essential legislative function of NCRB or the state.
Not a legislation for power. Is it permissible under the constitution to
Your
give
Lordship,
to some agency policing or investigation under the CRPC or judicial act to some private agency? When such being the case, invariably this procedure act has been enacted to aid CRPC, that means investigation.
certainly.
Investigation is invariably, it is the sovereign act of the state. When such being the case, storage of data, collection of data, storage of data, invariably for the purpose of investigation, and that too for a purpose of saving of 75 years, whether it is permissible for the NCRB or for the state to delegate that act, or administrative act or executive act to some private agency.
Certainly, and Your Lordship, interestingly, that question had also been raised in the case of Justice K.S. Puttaswamy, where the contention was regarding the Aadhaar Act, Section 57, and that in that very case it was laid down that whenever we are giving such data to a non-state actor, that threefold test had to be fulfilled, and that the state has reasonably put forward why that threefold test has been fulfilled in the present case, which is why we are contending that this action is rather not non-permissible in nature. Obliged. Thank you. It was an honor arguing.
And I request the faculty in charge, Ms. Bijoya, Assistant Professor of Law, KLE Law College, to introduce the judges and present the souvenirs.
Respected judges and esteemed guests, we welcome you to the 8th Surana and KLE Law College Constitutional Law Moot Court Competition. We are honored to have Honorable C. V.M. Ananda Shetty, Honorable C. H.S. Mallikarjuna Swamy, and Mr. K.N. Nitish. It is my distinct honor to introduce our esteemed judge for this session, Honorable C. V.M. Ananda Shetty. His Lordship presently serves as the Principal District and Sessions Judge at Kolar and has rendered distinguished judicial service across various districts of Karnataka. With over 22 years of experience in the legal field, including 12 years as an advocate and 10 years on the bench as a district judge. His lordship brings with him profound judicial acumen and extensive courtroom expertise. Prior to his elevation, he practiced before the trial courts and the High Court of Karnataka. His areas of competence include civil, criminal, and anti-corruption laws. He was selected as a district judge with first rank in the 2015 batch, reflecting his merit and commitment to the administration of justice. He has appeared for Common Selection Defense Services. We are truly privileged to have such an accomplished jurist among us today. May I please call upon stage Honorable C.K. Viresh Kumar, Additional Chief Judicial Magistrate, Bangalore, to hand over the sapling and souvenir to Honorable C. V.M. Ananda Shetty. Sir. Thank you, sir. Now we call upon next our judge, Honorable Mr. H.S. Mallikarjun Swamy, who is presently serving as District and Sessions Judge, Bangalore, with prior judicial service in Tumkur and Mangaluru. He holds a BSc from Mysore University and LLM from JSS Law College and an MBL from National Law School of India, University, Bangalore. Before joining the judicial service, he practiced as an advocate for 17 years, handling civil, criminal, and consumer matters. His extensive experience at both the bar and the bench equips him with deep insight into trial practice, procedural law, and judicial adjudication, bringing seasoned courtroom perspective to academic and advocacy evaluation. Thank you, sir, for being with us. I now call upon Dr. Shada, Assistant Professor of Law and HOD of BBLLB, to hand over the sapling and souvenir to Mr. H.S. Mallikarjun Swamy. Thank you, ma'am. It is my honor to introduce our next guest, Mr. K.N. Nitish, who is an accomplished advocate practicing before the High Court of Karnataka and various subordinate courts, tribunals, and quasi-judicial forums in Bangalore. A distinguished alumnus of KLE Society's Law College, Bangalore, he has secured gold medal in level law and second rank in the university upon completing his BLLB integrated course in the year 2010. He has been enrolled with the Karnataka State Bar Council on 3rd December 2010 under the guidance of Sri K.V. Narasimha. He has over 15 years of experience specializing in civil, criminal, civil, commercial, and service matters, representing both public and private sector clients. He is associated with the KVN Law Offices, Bangalore, and is empaneled with the institutions including the High Court of Karnataka, Mangalore City Corporation, Sri Shudha Cooperative Bank Limited, Food Corporation of India, and serves as a special counsel for the government of Karnataka. He is known for his strategic litigation and advisory approach. He is also a regular resource person, guest speaker, and adjudicated moot courts and legal competitions across Karnataka. Thank you, have you, sir. I now call upon Mr. Tanmay J. Patil, Assistant Professor of Law, to hand over the sapling and souvenir to Mr. K.N. Nitish. Thank you, sir. We, honorable judges, we express our heartfelt gratitude for gifting us our valuable time and expertise. Thank you, sir.
The round is complete. Thank you, everyone. Judges, please escort the judges.